Good afternoon, ladies and gentlemen. I'm Frik Lampman, CEO of Stellenbosch Graduate Institute. I see our audience members are signing in at the moment. We had about 140, 150 registrations, but as history has shown that they all don't come online immediately. A number of these people come back for the recording, which will be available after this on the website. We will tell you a bit more about that in a moment. Can I just ask you, for especially those of you new to this, mics and videos on mute, please. And then you will see on your screen, there's a white ribbon to the left where you can see who the people are that are joining. But right at the top, you will see public chat. If you click on that, it will widen the ribbon and you will see that you will be able to pose your questions there. And I will be the one that will watch those questions. And if I find an appropriate place in the conversation, I will feed that question into the conversation. So it is 12:31. We can start while Wayne in the background will allow the others to still come into the conversation. This Director's Hour, for those who are also new to the audience, is an initiative between Stellenbosch Graduate Institute, who is an interactive online business school offering business and executive education. And then, of course, our esteemed partner, Fluid Rock, who is a leading independent governance development organization. And because of this act, which we are going to discuss today, and especially the expertise that Fluid Rock has in the area of governance, and in particular, POPIA, and the training of that, we thought it well to invite expert guests into this conversation. And we've also asked one of Fluid Rock's members to lead the conversation for us today. And I want to introduce him, Mr. Harry Pretorius. Harry is the head of compliance and ethics at Fluid Rock. And with all his credentials, too many to mention here, and his education in the legal and compliance environment, he's also a certified compliance and ethics officer, and we thought he would be the great person to lead this conversation. I will hand over to Harry now, who will introduce the speakers. I will move to the background and feed in the questions if and when necessary, and then try and sum up at the end. But welcome. Hope you enjoy the session. Of course, a very wide subject. We will not be able to cover everything, but we will do our best to get to the gist of this. Harry, welcome, and welcome to the speakers. You're welcome to take over. Thank you.
Good morning, everyone. Thank you very much for attending. Thank you very much for the introduction, Frik. Obviously, my qualifications and experience pales in comparison with the speakers that we've got. We have the privilege of hosting today. Firstly is Advocate Lebogang Stroom-Nzama. She's a full-time member of the Information Regulator. She is an admitted attorney of the High Court with a LLM in specialization in commercial law, as well as a certificate in compliance management. She has worked with various financial institutions prior to joining the regulator, and she's also currently practicing advocate at the Johannesburg Bar. Then we've got Mr. Sizwe Snell Kamentuze, also a highly illustrious part-time member of the Information Regulator. He's got more qualifications than I've got fingers and toes to count with. And he's a part-time member of the Information Regulator, and then a part of the executive members or the executive management of the Information Regulator is Mr. Nemasisi. He's the executive in charge of the Promotion of Access to Information Act. And thank you so much for all three of them making the time and availability to join us. Obviously, time is of the essence, and we're limited to time. So I'm going to jump straight into a number of questions that we would like to pose to the panel of illustrious regulators. If I may ask, and we'll try and keep it short and sweet, briefly explain the main purpose of POPIA and PIA for those in the audience that may not be familiar with the legislation or the terms, and it will also be helpful to explain this at the hand of examples of what could constitute offences under the legislation.
Thank you very much, Harry. Thank you very much, colleagues. And I think it's a pleasure for having us on this session as the regulator. Let me start by saying, firstly, that the regulator, we took office in December 2016, and we have a dual mandate, meaning we responsible for POPIA, the Protection of Personal Information Act, and also for PIA, the Promotion of Access to Information Act. So one of the few regulators in Africa with a dual mandate. And also our constitutional mandate also derives from Section 14 of the Constitution, which deals with right to privacy, and Section 32 of the Constitution, which deals with access to information. When we started establishing this regulator, we went overseas to do some benchmarking exercise on those regulators that have a dual mandate like us. For an example, we went to Germany, the UK, and Canada, and we found mostly that what will be viable is the Canadian model, because they also have dual mandate and they're responsible for these two pieces of legislation. As you know, Harry, POPIA is mostly on the protection of personal information, how responsible parties should process personal information of data subject. They must do that in a responsible manner. And issues of access into information in terms of PIA, which is still with the South African Human Rights Commission, it's your right to access to information in order to exercise your right in relation to have access to that right. So basically, we are mandated we have the responsibility, we are the custodian of these two pieces of legislation. Like I said, in Africa, I think we are few. I think Ghana, I think we are few, one or two regulators that have a dual mandate. So our regulator in terms of the organization, it's mostly based on the Canadian model in terms of even the staff and the organizational structure. So that what informed the regulator at this stage. And I'll briefly, on the second part of your question, go through some of, just to list examples of those offenses. As you know, POPIA imposes administrative fine of not exceeding 10 million for non-compliance. And I'll just, under POPIA, list certain sections which constitute violation and have penalties. For an example, Section 103 of POPIA, if you fail to comply with an enforcement notice in terms of Section 95. Section 103, 2A and B also has a fine or imprisonment period not exceeding 12 months. Section 105 also under POPIA has a fine or an imprisonment period. So under PIA, the relevant sections that have those specific offenses will be Section 91 of PIA, which also has a fine or an imprisonment not exceeding 2 years. Section 92 in brackets, also a fine. Section 93, also there's a fine there. And Section 77, I think is the new 77 capital A for PIA as amended by POPIA. So those are examples of the sections under POPIA and PIA, which outline specific offenses and the penalties in relation thereto. Thank you, Harry.
Lebogang, thank you very much for the explanation. But for the layperson, what does that mean? Does the act or these pieces of legislation, does it affect only the big corporates, or is it every small little corner shop as well?
Thanks, Harry. Like I said, there's two pieces of our legislative mandate emanates also from a constitutional mandate, so it impacts everybody. So whether it's a small business or a big business, everybody, a responsible party, anyone who processes any personal information of a data subject must do it in a responsible manner. In under POPIA, it means there are 8 conditions that you need to comply in. Those are the cornerstone in terms of when processing personal information, you must comply with all those 8 conditions as they are listed in POPIA and do so in a responsible manner. So it's applicable to anyone, any person or any company or any small shop somewhere. If you are just processing personal information of any person, you must do it in a responsible manner.
Responsible manner is a theme that runs through both the pieces of legislation. But something else that's become quite apparent from reading the pieces of legislation. Obviously, the compliance levels for a big corporate versus the small corner shop or the security access at the estates is going to be different. And the theme that we're picking up there is reasonableness. Can you confirm that?
Yes, Harry. Remember, before, I think the question now is, how do we start? Since POPIA is an act, where do I start as a big corporate or a small organization? I think what is important is to do your impact assessment in terms of the act. Look at your organization, the nature of your business, how you've been processing. If your business processes are now not in contravention with POPIA, you must try to align with that. Obviously, yes, the act speaks about reasonableness. I mean, obviously, you can't say it, you can comply with all. There are certain instances where there'll be gaps, but there are exceptions also in the act. But you must also try to process that information in a reasonable manner. What I mean by that, the processing, the conditions, accountability, consent under process limitation, purpose specification, the purpose that you process personal information for, further process limitation as referred to section 15, information quality, openness, meaning a person who you are processing information on his behalf must know that you are processing their personal information. And security safeguard, what measures do you have in place to ensure that you protect the integrity of that personal information within your organization? And also data subject participation. I need to know at a certain point and correct my information if you are holding my information as a responsible party to ensure that even though you are processing it, it's accurate and correct.
Absolutely. Thank you very much. And then obviously, seeing that we're dealing here with governance today, would you please be so kind as to explain your governance structures within the regulator? What's the members and the executive management? What exactly does that mean to the average person?
Okay, I think I'll start here. As the regulator, we are appointed by the state president in 2016 on recommendation by National Assembly. So we are 5 members. 3 are full-time, 2 are part-time. The 3 full-time members is the chairperson and 2 ordinary members, myself and Advocate Wipond. The 2 part-time members is Mr. Snell Kamdusi, and the other position is vacant as Prof. Dana has resigned. Now, what we have is that we started our phased-in approach in terms of recruitment. Now, at executive level, we've got the CEO, we've got the CFO, we've got Mr. Nemesis, who's the executive for PAIA. We've got Advocate Kilauto, who's the executive for POPIA. We've got Ms. Shube, who's the HR executive. We've got the executive for legal research and policy and technology analysis, Ms. Sulal. So we've got all in all 6 executives. Now we are in our phase 2 level where we're trying to recruit now senior management in terms of managers beneath the level of the executive. And that area is informed by our organizational structure, that also the benchmarking that we did in terms of how do we capacitate the information regulator. So as you know, we are not a board per se. We are members and we are accountable to the National Assembly. The CEO is an accounting officer in terms of POPIA and also in terms of PFMA. So actually in terms of governance, you can see that our reporting line is directly to government as members, but our CEO is also in terms of POPIA an accounting officer and also has certain responsibilities that he must comply with in terms of also PFMA. And also section 49 of POPIA mandate us to have committees of the regulator. So if you go to our website, you'll see those committees, but they have been since reviewed to align to the organizational structure of the regulator and the executive positions that way we have filled of all the executive. So the terms of reference of each committees are under review, and once they are being reviewed, we'll publish the new committees as per section 49 of POPIA. Thank you, Harry.
Yes, perfect. Thank you so much for clarifying that. It's quite a unique and complex structure by the sound of things. Then, if I might ask, obviously, is everyone is aware now of papaya and paya and all of that. What are the relevant timelines pertaining to compliance, but related to both pieces of legislation, if I might ask?
Thank you. As you know, that last month the president has promulgated POPIA, and the PAIA function is still with the South African Human Rights Commission. As of, remember, the operation of Section 1110, 100, and 110 and 1144 is suspended up until early next year, 1st of July. So by the 30th of June 2021, the PAIA mandate will move over to the information regulator. In time being, what we are doing, we have a memorandum of cooperation between the South African Human Rights Commission and an action plan in place to ensure that come 1st of July 2021, we take that mandate from the Human Rights Commission smoothly and seamlessly. The transition must be smooth so that now we will be the custodian now of both PAIA and POPIA. But as you know, the grace period for compliance with POPIA, you've got 1 year after POPIA has been promulgated to put your ducks in a row to ensure that you comply with POPIA. So it's a 1 year grace period. We don't want to talk about the extension of the period by the minister at this point in time. We're just saying the grace period for compliance is just 1 year. Yes.
Much. And then, if I might ask, what's the plan surrounding the current PAIA exemption? Is there any plans afoot to extend it past the December deadline?
Yes, sir. Remember the moratorium extended up until December. So what the discussion between the regulator and the Human Rights Commission is that they'll approach the Department of Justice for an extension of the moratorium from 2020 December up until July, 1st of July next year. So those private bodies will be exempted, will be covered. So we'll extend that exemption to cover those private bodies for submission of manuals.
Just to be clear, that exemption only relates to PAIA and not to POPIA.
Yes, PAIA, submission of manuals by private bodies. Yes, here.
Then, obviously, as you mentioned, the 12 months grace period, time is ticking and time is running. What would you recommend from a practical perspective? What should the first steps be? I mean, I know you've touched briefly on it before, but as an organization, as a small 1 or 2 man type of company, what should be your focus at this stage?
I think the first step, you should look at your privacy impact assessment. You should look at your organization and look how you've been doing your business processes and look at what POPIA prescribe and try to align your business process with POPIA in that 1 year, because even before the grace period, even before POPIA was promulgated, we encouraged proactive compliance with the Act so that when the grace period also kicks in, you are ready within that year to conform and to comply with the Act.
Thank you for that. Then, what is regarded as personal information? And please provide the attendees with some real life examples, so make it tangible and so that they can understand the impact and the scope of these pieces of legislation, and as well as the need for the information. I mean, it's just to, as you mentioned earlier, it's to align us with the international community from a privacy perspective as well.
Harry, I'll go to the Act because the definition of personal information is very extensive. It's information relating to your race, your gender, pregnancy, marital status, social origin, color, mental health, well-being, belief, cultural, language, financial, criminal, employment, history, medical. So it's a lot. Even your biometric information about a person. So it's a lot of the definition of personal information is very wide. You have to go through the Act and unpack because it's not a single line. It's a lot of things that constitute a person's personal information.
Something that's quite unique to the South African environment is the juristic entities are also protected by POPIA. What exactly does that entail, and what does that mean on a practical basis?
POPIA applies to both existing jurisdic person and natural person, excluding people who have passed on. So it's clear that it covers both me as a data subject, a natural person, and also a company, which is a jurisdic person. Because in practical terms, if a company is processing personal information in terms of POPIA, it will be a responsible party. If it is processing my personal information, I'll be the data subject in terms of the Act. So it protects both. So persons, the definition of persons includes both natural and jurisdic persons.
And then from a juristic person, what type of information would it protect from a juristic person then?
It will depend what type of information as a juristic person you are processing. It's the nature of your business. If you're in a business of banking, it means it will be banking finance related information that you as a juristic person needs to protect because it's information relating to a particular data subject. So it will depend. Hence, I'm saying here, what will assist is for each and every company to start doing a privacy impact assessment. Look at the nature of your business, look at your business processes, and that will assist you in terms of aligning your processes with POPIA.
So much, yes, that's definitely helpful. And then earlier on, you mentioned all these sections and the fines and penalties. It's quite. What are these fines and penalties, and what is the regulator's view regarding enforcement? Are you planning on starting enforcement as of the 1st of July 2021? And also, as an additional question, will naming and shaming of breaches form part of such penalties and fines?
Yes, Eric, for interest sake, we do have one of the committees, the enforcement committee. Remember the reason why PAIA is now amended and is with the regulators that previously it didn't have powers. For an example, with the enforcement, if you are unhappy about anything in PAIA, you just have to go to court. And how many people afford to go to court? But with POPIA now, the internal remedies, you've got what you call an enforcement committee, where a judge or a magistrate of whatever, yes, will be sitting there as a designated chair of that committee, so that we first exhaust internal remedies. We give people remedies within the organization because they can actually to go to court. So with relation to the administrative fines that we levy, yes, after the grace period, we've got powers to levy and issue those administrative fines. And if you go to the Act, you can see it's a fine of a certain amount or an imprisonment of a certain period. But yes, after the grace period, we are empowered to levy those fines.
Are empowered, but what's your intention? Are you planning on coming down with an iron fist immediately, or would you rather adopt a more collaborative type of approach?
The prudent approach is that you've got one grace period. You need to prepare yourself. And once I'm in that grace period, after the grace period, we are legally bound to issue those fines. So in the meantime, prepare yourself. And I don't think we're coming as in we are a bad cop. No, we are saying comply. Hence, even now we are saying we're encouraging proactive compliance with the Act. We know that there have been breaches, but what we're trying to say is that we issue Section 2022 notice to say, ensure that you come back to us, you tell us what have you done in light of this breach. So we are trying to encourage that proactive compliance so that after the grace period, people actually are able to comply with the Act, because those sanctions will be in operations.
Quite important to note. I mean, obviously, the big corporates would be able to weather a big fine or penalty, whereas the smaller businesses, if they get levied with a penalty or a fine, it might close their business completely.
Yeah, but as you might know, what we have noticed with the complaints, the private sector is willing to comply more because the 10 million will affect their bottom line vis-a-vis municipalities. That's what we have. So obviously, I mean, it will depend on even you say small organization, but the turnover, will it be in that amount? No.
Absolutely. And then you actually lead into my next question. Who will be responsible if government departments share personal information with state-owned companies and or private companies, which is happening as we speak?
Mr. Pretorius, I think that part of question I'll be taking over from Mr. Snail, because that's the part 3 that he needed to address. So I don't know whether you want to address with me now or with Mr. Snail, because it's part of Mr. Snail's question that he must address today on the seminar.
I'll await Mr. Snell's reply on that then.
Okay. So your question is, Harry?
My next question then, apart from the government, who's responsible for the government, then is I'll address that question with Mr. Snell, is the COVID pandemic. Obviously, all of us are sitting at home with load shedding and all of that. What impact does it have on the regulator stance pertaining to the collection of personal information? And if so, what is your take on this?
Okay, that's also Mr. Snail's question, but I'll say in light of COVID, we have issued our own guidelines in terms of COVID-19, and because the regulations that were done by government were done in haste because of the pandemic, we didn't take part in those regulations. But I'm pleased to announce that we are in consultation with the designated judge as it relates to all of this COVID issue. And Mr. Nemesis will also touch on the document in terms of Section 40 that we have submitted to Parliament in relation to what should happen after the pandemic is over in terms of personal information of people that has been collected. Remember, there was a tracing and tracking of people by telecom. So those issues, I think Mr. Nemesis will also touch on his part of questions in more in detail.
So much, Advocate Sturm Zama. Really appreciate it. Mr. Snell, I see you've joined us. Is if I may pose my previous question that I posed to Advocate Sturm to you now. Who will be responsible for government departments if they share personal information to state-owned and/or private companies?
Well, in the case of government departments or organs of state, I think they have the same duties as any other responsible party to ensure that they protect personal information and to ensure that they comply with the 8 principles pertaining to POPIA. Obviously, there is no express prohibition on the sharing of information if there is a law that allows it and it is justifiable to do so. But also in the sharing of that, they will have to comply with the 8 principles, such as the security of the information, such as keeping the information regularly up to date, and so forth.
So much. Then the next question is a quite a relevant question. I don't know if you saw the news this morning. Instagram is apparently being dragged to court in a court in Illinois, and they're on the hook by the look and sound of things for at least 9 trillion rand. I'm too stupid to do the conversion into dollars. How would the cloud IT service providers like Google and Facebook and Instagram be viewed by the regulator?
Well, it's the whole situation of keeping personal information on behalf of someone or on behalf of an organization on your cloud. Now, obviously, if the information is kept here in South Africa, then POPIA fully applies. Once again, the cloud service provider would have to comply. You will notice that some companies like Google, they are now starting to have data farms here in South Africa. So it is not necessarily the issue of trans-border sharing of information. But in the instance where there is trans-border sharing of information, the POPIA also specifies that if you are doing a form of trans-border sharing of information as a service provider, you must still adhere to POPIA, or you must do so in a country that has an adequate standard or equal or even better data protection standard than that of South Africa. Now that you mention America, you will notice that the EU Shield and the America Shield between those 2 countries was also declared unconstitutional by the European Court. So I'm not surprised that there are these actions that are going to be happening in America, as data protection there has really been a political issue, but they are finally following up with the international trends, and let's see what the courts have to say.
It will be quite interesting to follow that. Definitely agree. Then the regulator has indicated previously that there's going to be sector-specific codes of conduct that will be issued. What sectors would be prioritized during this 12-month period, and what progress are being made pertaining to that?
You will notice on the section dealing with codes of conduct that the codes of conduct, first of all, they're not just for the taking. I always like to emphasize that. The amount of codes of conduct will be limited by the relevant industries or professions or bodies that really are in desperate need of a code. The regulator has initially focused on telecommunications as well as the health sector in terms of the codes that we are going to initiate on our own initiative. That is our focal point for the starters, but that doesn't prevent anyone, or should I say any relevant body or any vocation or industry or profession from approaching the regulator with their proposed code. And then obviously it will have to go through the relevant steps in terms of the guidelines to codes of conduct, which are currently being finalized by the regulator, so to enable people to actually bring these codes for consideration. I hope that deals with that question.
Right, sir. Thank you very much for that elaboration.
Okay, Harry, can I just quickly put a question in here from the audience? It relates maybe to one of the things that you've asked Mr. Mtuse just in the previous question, and maybe what Advocate Nzama said. And Shanda asked, does POPIA protect an individual's information in terms of FICA? Because the question is, accountable institutions are given a lot of freedom to request information that they find reasonable to establish and verify identification of natural persons. So in what way are these requests from these accountable organizations, are they being limited by POPIA? And to what extent is that information being protected? Should they then give that to a third party?
I've always insisted to say that the POPIA is not a prohibiting act. It is an enabling act. It is an act that enables people to have a particular standard in how they keep personal information, share information, as well as ensure that it is kept confidentially. POPIA does say that where the law requires that information be shared, then obviously in terms of those prescripts, the POPIA does not inhibit that. And if you also look at sections 5, read together with section 6, it is very clear that in the cases of criminal investigations, in the event of crimes pertaining to money laundering and the likes, the POPIA does not prevent the relevant authorities from carrying out their jobs. But we always emphasize that even those relevant authorities, even when they are authorized to process this personal information, there may be some of the other principles that they would still have to comply with. For instance, let's say FICA, for instance. In terms of FICA, you're not necessarily going to give consent because they will have that information that would have been given by the banks. But it doesn't necessarily stop the Financial Intelligence Center from having proper and secure information systems to ensure that the information that they keep is safe and secure and that it is not compromised whilst it is kept by them or whilst it is given to another agency of the state that they may be carrying out an investigation. So once again, POPIA is not a prohibitory act, it's an enabling act. It is there to change the culture of how we process personal information. And even in the instances where the law allows it, POPIA still comes in and says, but please respect the data and at least have a minimum standard in terms of how you process this personal information. I hope that explains that.
Thank you so much.
A very refreshing look at that, and I absolutely completely agree. Another state entity that's completely mentioned specifically is also SARS, the revenue services.
Yes, you will note that once again, tax affairs is a very contentious point. There's actually currently a court case that is between the former president as well with SARS, as well as a party that seeks to get his tax affairs. The general presumption is that your tax affairs are your tax affairs, and only that the taxman can communicate with you regarding that. But we are yet to see what the courts have to say regarding the personal information relating to tax affairs. But POPIA, like I said, once again, does not inhibit SARS. It just enables them to do it in a particular fashion that is ordinary.
So much appreciated that take on things. Then the Act provides that the regulator may exempt responsible parties from processing personal information. What would the process be to apply for such an exemption, and is it actually worthwhile?
Well, in the case of an exemption, like I said, the exemptions are quite close to the codes of conduct. The codes of conduct are there to cover a broad industry. And then in particular instances, there may just be a particular act of processing that you may want an exemption for. So I think the exemption is more meant for the ad hoc type of personal information that you may want. It is not necessarily meant for exempting a industry or a profession. It is more meant for specific instances of processing, and that would obviously have to be done in a prescribed way in writing to the regulator, and you would have to justify as to why you seek that exemption. Thank you.
Thank you so much. Then you've mentioned the EU and the US earlier and all of that. What is the main difference, if any, between the POPIA and the EU General Data Protection Regulations? And does the regulator work in conjunction with other international information regulators? Although Advocate Stroom did mention something earlier.
Yes, look, I always say that data protection it's not a European phenomenon. It's not an American phenomenon. It stems from the right to privacy. And data protection has always been a contentious issue. It's been a contentious issue during the World War. It's been a contentious issue during apartheid South Africa. It's been a contentious issue during the Anglo-Boer Wars. So the protection of personal information is really something that is important. And it is really, we have an international trend now when it comes to personal information. We don't necessarily now have a model law that one can follow, but in terms of our own constitution, you will note Section 233 is very clear. It says we may consider foreign law, but must consider international foreign law. So things like the GDPR, the Privacy Shield, as I mentioned, although that's been now rendered unconstitutional, those are international law instruments that the regulator will use in interpreting its own laws. And hopefully the courts, if the regulator is taken to court, will also have to look at these factors into consideration. Thank you.
Mr. Mtuze, you mentioned if the regulator is being dragged to court, would there be any instances where the regulator might or will initiate legal action themselves?
Yes, you will note that the regulator is empowered to institute legal action on behalf of a data subject or on behalf of a group of persons in the event where there has been a serious breach of personal information and the regulator feels that damages should ensue in addition to whatever fine that the regulator may give. You must, however, also appreciate that whatever functions that the regulator will be doing, that those are administrative action. And the Act is very clear that if you are unhappy with the decisions of the regulator, you still are entitled within your right to ask for an appeal, which in actual fact would be a review of the decision of the regulator. to the High Court. Thank you. I'll give over to Mr. Nemasisi now for the rest of the questions.
Nemasisi, thank you so much for joining us. I think a lot of the questions have been raised, have been addressed with Advocate Stroom and Mr. Matuzi. But the one question that I would want to answer, if possible, what is the regulator's view and stance pertaining to data breaches that have occurred prior to the commencement of POPIA?
I'm not sure if we've lost Mr. Nemasisi there. I think I'll just answer that for now. The attitude of the regulator has always been that we are taking a proactive stance towards compliance. And for the last 2 years, we actually have an active data breach register in terms of which parties who have experienced a breach are self-reporting to the regulator in terms of Section 22, and they are following the prescripts of Section 22, which includes reporting to the data subjects as well, and ensuring the regulator that steps have been taken to ensure that there are no further data breaches.
Pertaining to that, is argumentative sake is I've got a big database and there's one breach that I get picked up, and which only relates to one data subject. Do I then need to inform my whole database, or do I only need to inform the one data subject pertaining to the breach or such a breach?
When it comes to data breaches, the position is quite interesting. I always tell my students at university that it is not a quantitative approach, it's a qualitative approach. Has there been a breach to a particular database? The fact that one particular individual's information may have come across as having been breached, the mere fact that that particular individual's information was part of a database, there would be a reasonable apprehension that the remainder of the personal information that was on the database was also compromised. Therefore, I always say it is not a quantitative investigation, it is a qualitative investigation, and people should be guided by that accordingly.
Thank you so much. I see the time is after 1. Do we want to open the questions to the panel?
So, Harry, I haven't got any other questions coming in from the side, but maybe one of the things one would like to know is when I've listened to Advocate Nzama, I had a sense that the concept of processing is a very wide definition. So would it be difficult for entities like any other organization or whoever processes information to really understand what processing means in the current definition? What guidance does one get to understand what does processing mean?
Thank you very much. Processing, we look at it as in processing as defined in the Act. Any operation or activity or any set of operation, whether or not by automatic means concerning personal information, including the following: the collection, receipt, recording, organization, collating, storage, updating or modification, retrieval, alteration, consultation or use, dissemination by means of transmission, distribution or making available in any form, or merging, linking, as well as restriction, degradation, erasure, or destruction of information. So when we talk about processing in the Act, or there's a complaint, we look at the definition of the Act of processing as in the Act. If you are performing one or more of the activities associated with processing in the Act, then you'll be processing personal information of a data subject.
You can hear quite a broad application.
Yeah.
If I may just add, there is no numerous clauses as to what processing is. The Act does say a particular list, but there may be other forms of processing, let's say in the future or by way of technology, that may not be encompassed in there. Just wanted to add that.
Yes,
Thank you so much. But the mere fact that biometric information is included in the definitions is already broadened the scope of the legislation, I believe, to cater for the future then as well.
Yes, definitely. I don't think the intention of the legislature would be to exclude technology. I mean, this act was drafted in the age of the fourth industrial revolution. So it most probably would never have been the intention of the legislature to exclude any further forms of technological processing. I think those would be included as well.
Maybe for the lay person out there, Harry, and your panel, I want to link two concepts, and that is one of the good things that I've heard here is that it's an enabling act, and the other good thing that I've heard is the question of reasonable. So in this here that we have an opportunity to get to grips with this act and in the implementation and cleaning out our databases and the processes, etc. What kind of guidance can we expect to what does reasonable means in this process? And what does enablement means in this process while implementing this act?
I'll answer the reasonableness of the part of the question. Condition 2, which relates to process limitation, talks about lawfulness of processing. It means personal information must be processed lawfully in a reasonable manner, meaning in a manner that doesn't infringe the privacy of a data subject. So we have also previously sat down and tried to look at what is reasonable, because Harry, as you know, what will be reasonable in organization in processing might not be reasonable to the other. So I think it's those kind of legal concept and application when we look at POPIA, we need to balance, because if you're processing personal information in a manner that you don't go overboard and infringe my privacy, then the reasonableness will come into play. Mr. Snell, you'll address the enabling legislation part thereof.
Can I bring in a question from the audience? Sorry, I see Mr. Matuse is coming in. I'll hold back.
Yes, you can ask the question first, and then we'll address that.
The question from Candace is, in the case of a partnership of two business entities, are both parties seen to be responsible parties?
Well, it's not a classical POPIA question, but being an attorney, I guess I'm qualified to answer it. A partnership is legally responsible for the consequences of everything that happens in the partnership. So the partners of the partnership would equally be responsible in terms of being the responsible party. So yes, if anything within the partnership were to go haywire, then obviously both the partners would be responsible in terms of POPIA if there's any reporting or if there's any fines that have to be dished out in terms of non-compliance.
So maybe here's a more direct POPIA question coming in, Harry, from Nicole. Section 22 of POPIA does not include a test for materiality or risk of harm for data breach reporting. How will the regulator manage the volumes of data breach reporting, and will the regulator be adopting an online breach reporting function?
I think that's a operational question, which I think I'm not at liberty to respond at this particular time. But the attitude that the regulator has taken is that all breaches that are reported will be dealt with. I mean, obviously, now that POPIA is going to be fully law in a year's time, the number of data breaches will increase. We will not be seeing the number of data breaches that have been reported to us thus far. So I think it is something that will have to be assessed as we go on. and as the data breaches are reported. But one of the, should I say, policy decisions that the regulator has taken is that we are going to try to be as accessible as possible to the public, be it by way of electronic means, be it by way of walk-ins, be it by way of having an electronic interface where you could possibly file your complaints and thus forth. So I think it's, I wouldn't say it's a premature question, but I think it's something that we are going to have a look at. Now, in terms of materiality, I think it goes back to what I said. It is not a quantitative approach, it is a qualitative approach. You know, has there been a breach or has there been a suspicion that there has been a breach? I think that is the test. And whether it is only one personal information that leaked, the mere fact that that particular person, that culprit, had access to this database, let's say a database, for instance, that in itself is material enough to have to report the breach. I usually then get the question that says, so what is if only two people's personal information was breached? Then you still report it because it is a qualitative approach and not a quantitative approach. Thank you.
Yeah, I think if I might butt in here, I do agree with you. But also seeing that we're apart from the fact that we're under lockdown, but obviously the rise in phishing and internet scams and all of that has definitely increased, and obviously that has got a direct impact then on data breaches as well, from a number of sources down the supply chain as well.
Yes, the coming of COVID-19, I think, was a bit of a surprise to everybody. No one knew that to buy a pizza, you'll have to use a delivery man to come and bring it to you. No one knew that in order to attend a conference, would be sitting online as we are here today and having 55 other people in all over the country looking at this, you know. So it has brought a lot of challenges to us, but the challenges that COVID has actually brought go to the crux of the work of the regulator. You know, that is why even when COVID started and there was the whole issue of contact tracing and the whole issue of reporting to the authorities about your status, the regulator actually went and had a guidance note issued. And you will also note that there is a COVID-19 designated judge, Judge Kato Regan. The regulator has also been in contact with her, although her mandate was very limited to the contact tracing. I think the regulator has accepted that COVID-19 has actually brought the challenges that the regulator needed to test the law. And I think the amount of data breaches, because of the amount of cyber criminal activities that has increased, will increase. And that is just something that we will have to deal with, and we will see. Time will tell.
Thank you.
Absolutely. I believe that the pandemic has definitely accelerated change in more ways than one.
Yes, Harry. Adding on to what Mr. Snail has said, I mean, we have even taken an initiative to write to Parliament in terms of Section 42 of our Act to advise Parliament on what should happen after the pandemic as far as it relates to the collection of personal information that happened during the pandemic. So COVID has really affected a lot of operations in terms of also POPIA, because all that information that has been collected after the pandemic, what will happen to that personal information? Are they going to keep it for statistical purposes in future? And if so, they must do it in terms of POPIA. Are they going to destroy, delete, or de-identify that information? So we have written also to Parliament to advise them to say, these are the issues that you need to consider at the end of the pandemic so that we protect and secure personal information which was collected during the pandemic.
Harry, I don't know if you have any other questions, Harry, or I see we are getting to the end of our hour. It's 13:26. Unless your panel wants to make some concluding remarks.
It would be valuable if we may invite Advocate Stroom and Mr. Mtuze to address us with a final concluding remarks, if they won't mind.
Yes. From our side as the regulator, we take these sessions and discussions as ongoing. We don't want to see it as a session that only happens today. There are a lot of issues that we need to really discuss. It's just a pity there's this pandemic and we can't meet face to face. But I think, Harry, you take this discussion forward, and a lot of questions that have been captured also that we didn't respond to, and also, like I said, some policy decision issues. You still need to engage each other going forward so that, you know, when time comes for us to fully comply with the Act, we are at the same understanding and same level of understanding in terms of what are the issues that we need to comply with POPIA. If there are any issues that sort of hamper you in terms of complying with the Act, you need to bounce that with the regulator to say, look, this is our business processes, and how do we come about to, you know, we can give advice to companies, to private bodies, to public bodies in terms of how they can implement POPIA, but we are very wary of giving legal advice, because you can also use that against us to say, now, you know, you advised us this way. So we can assist bodies to comply with POPIA where we can. I think Mr. Snail can add also if there's anything that I have left out.
Yeah, I think Advocate Storm Zama has covered, I think, the concluding remarks. I think the regulator is here for everyone. We're a constitutional body. The regulator is here to stay. Even after this present regulator completes its term, there will be another regulator. So people need to really adjust the mindset when it comes to data protection, and accept that data protection is not a European concept, it's not an American concept, it's a South African concept. It flows with our human rights, it flows with our right to privacy, and it is an enabling legislation. I know I've used this word, I think, 4 times already today, but it is very important that people understand that it enables processing of personal information and does not inhibit. Thank you.
Harry, thank you so much for facilitating this and for your panel. It is expected of me to conclude and summarize, which I find extremely difficult at this point. But let me say this, kind of a brief reflection on this. There was a time that we said time is money. And nowadays, I think that is changed, and we say data is money. And therefore, data as money is open for abuse. And I think we cannot deny the need for an act like this. And but complying with it is going to be a challenge for especially smaller entities who do not necessarily have always the deep pockets. But it's something that we need to do. And the good things that I've heard from this conversation from your panel are those 8 conditions, which I think the layperson or the entities must become aware of. What are those 8 conditions that you have to look at to ensure that you handle data responsibly? I heard the concept of reasonableness, which I also like in this process, because I think in the application we are going to make mistakes. Some things will have to change. The devil is in the detail. I would almost say the devil is in the application, and it's going to be a trial and error for a lot of us out there, especially as small businesses, to make this work. But I think the purpose of this and where it's heading is something that all of us can agree on in this interconnected world that we are in. So thank you very much. Thank you for the audience for joining us. Best of luck for the regulators in your big task that you have. Harry, I hope you have gained enough information here to work into your POPIA courses at Fluid Rock. If you need help, don't come to me, please go to the regulators. To our audience, this was recorded. It would be available on the website very soon. You will get a link to this as per your registration. Thank you very much and keep well.